Okay. All right. Where are we on this case, folks?
At the last hearing, we were reading on the evidences I sent. One was a flash drive.
Yes.
Due to the weather and the courts being closed, it hadn't been logged yet.
Correct. I think
also,
we have it now.
Yes. And I believe that your coordinator helped Mr. Stanford to play his flash drive.
Right. Did you get all the stuff off of the flash drive, Mr.?
I did see the video of the previous hearing on that, yes.
Okay. And so with reference to that previous hearing, you have something you're holding up. What are you trying to do?
I submitted to the court an answer to that, and I sent a copy to her. I don't know if she's received it or not yet.
Is that the response to defendant's objections and evidence submitted about January 15th, 2024 hearing? That's what you, okay.
That's right.
All right. Have you received that?
I have not.
Okay, folks. All right. All right. Somewhere along the line, we've got to make sure, because it becomes impossible for me to conduct a hearing where one party has submitted something and the other party doesn't have it. And I'm not saying, I'm not blaming either party. I'm just saying that's the cold-hearted reality of where I end up.
Your Honor, may I say
how did you send this to Ms. Norman?
U.S. mail.
Okay, well,
yeah,
that's going to be.
I thought our hearing was a little later in the month. I thought she was going to get it. And I just got the notice about our hearing date yesterday. So I was thinking maybe I should.
Well, that maybe should tell you something about the mail. All right. Here's what I'm going to do. I think we have Ms. Norman's email, right?
Yes, sir.
Okay. So, folks, I'm not sure that. Yes,
ma'am. Can I say something, please?
Yes, go ahead.
That video from the hearing from 10/22 of 2024 has on there where Mr. Stanford waived his right to monetary damage and rent because of the case, and my case being I dismissed my case in order to come to that end. So I don't know. I just feel like at this point, it's, we're just on the court's time and we're wasting it with,
well,
all of these things.
Ms. Norman, I understand what your position may be. My position is that if somebody submits something to the court, I have to at least look at it and consider it. The very fact, I don't think, if you think about the last hearing, you submitted something and I didn't get it because of whatever the circumstances were. I didn't have it. I don't think you would want me to proceed without having that. Mr. Stanford has submitted something. I'm not going to have a problem going through it. You just have to have it so that you can respond to it if necessary, because you're entitled to have it. Here's what I'm going to do. At this point, there'll be no additional filings. All right? Because I don't want to end up in this circumstance. We have Ms. Norman's email?
Yes, sir.
All right. So what I'm going to do to expedite the process, Ms. Norman, because normally I'd put it out however long it may take the mail to get there. I'm going to have my staff copy what Mr. Stanford has submitted, email it to you so that you have it. Okay? So
what happens then? He's got an answer to the video, and then I see something on his answer, but yet I can't answer.
Then you guys can argue that before me. Miss Norman, I can't force this to go any different.
I don't want to argue. I want it to end. I want it to end. And this is just how we were in October of 2024. Frustrating you.
So I am not frustrated. I'm frustrated by your failure to
I'm not a failure.
Permit the court to
I'm not a
proceed
failure.
with how it has to proceed. I just explained to you why I can't do it the way you want me to do it.
Because he submitted an answer. Is that correct?
What did I just tell you, Miss Norton? What did I just tell you?
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case.
And there it is, the moment the courtroom dynamic flips. What just happened wasn't about email. It wasn't about mail delays. It was about control of the courtroom. Judges have broad discretion to manage proceedings. Once a litigant repeatedly interrupts or challenges authority, the judge can shut it down. That mute her wasn't emotional. It was administrative authority in action. But here's the twist. The judge originally tried to expedite the process for her. Email instead of mail, faster resolution. When that offer met resistance, he reverted to standard procedure and extended the timeline. March 10th, 2026. That's not just a date. That's months of delay added in seconds. Now ask yourself, did frustration cost her time? Because in court, tone matters, respect matters, and sometimes the fastest way out is cooperation. And just like that, adjourned.